Good morning, friends. My name is Aniruddha Dilip Deshpande, and today I am going to explain the concept of privity of the contract. As per the rule, only parties who are entering into the contract can sue each other for any kind of damages or any kind of issues. It also means that a stranger to the contract cannot sue. So let us try to understand this concept by a case law. There is a case which is Arias Advertising Bureau versus C.T. Devraj. In this case, what happens? The circus owner Balkrishna placed an order with the plaintiff to make the advertise for his circus, but the advertiser did not make any kind of agreement with the financier of the circus. Later on, due to some issues, this circus got shut down, and plaintiff sued the financier of the circus for the recovery of the dues of his advertisement. In this case, Supreme Court said that because a financier is not a party according to the privity of the contract, hence he is not entitled to pay any kind of compensation to the advisor. So there are certain exceptions to the privity of the contract. Let us try to understand by one. So first one is the beneficiary of a trust or beneficiary under a contract. So there is a case law. We'll try to understand this by a case law. So there is a case as Clause Mitchell Beckett versus East India Hotel Limited. In this case, what happens that there is a contract between the German airline Lufthansa and Hotel Oberoi India, New Delhi, for making for stay arrangements for their crew members in their hotel. So in this case, what happens during the stay, this Mr. Mitchell Beckett, who is a pilot of this airline, he gets injured while swimming in the swimming pool at this hotel. So later on, Mr. Mitchell Beckett files a suit to claim the compensation regarding the injuries that he has suffered. So in this case, court granted Mr. Mitchell Beckett compensation, stating that though though he is not a party to the contract, but he is beneficiary to the contract, and hence he is entitled for the compensation for any damages that he has suffered. So second exception to the privity of contract is beneficiary of family settlements, marriage settlements, family partition, and all such agreements should be in writing. And then third exception is when a person acknowledges a receipt of money or confirms that he'll pay the liability of the other, then he'll be bound by such acknowledgement. So let us try to understand by an example. Suppose there are three persons A, B and C. B owes some amount to C, and in this scenario, what happens that A says to C that he'll pay on behalf of B whatever amount B owes to C, that he will take care of that and he'll pay on behalf of C. So in this case, if something goes wrong, then he can he is entitled for the enforceability and all. Fourth exception is that in all contracts entered through the agent, then the principal or the principal company shall be deemed as the party. Fifth is law related to negotiable instrument. Let us try to understand through an example. So in this case, what happens that if A gives a check of rupees 5,000 to B, then when B goes to a bank, then it's bank's duty to pay B 5,000 rupees, though B and bank are not entering into the direct contract. So sixth exception is related to the land, agreement related to that land. So we can say covenant attached or running with the land. So a person buying land is bounded by the covenant or agreement affecting the land, although he may not be the party to the said covenant or the agreement. So let us try to understand this through an example. For example, if I am an owner to a land and I have been giving this land for like any kind of mela, for we can take an example of mela purpose. I've been giving this land for that purpose since ages. So now I have sold that land to somebody else, though he was not a party for this kind of agreement for giving this land for mela purpose. But as since I have sold it to that person, then again, according to this exception, the principal exception, he'll be bounded by the same covenant. So these are some exceptions to the privity of contract. So what we have tried to understand is privity of contract and exception to the privity of contract. Thank you so much.